May a state in the United States legally secede from the rest of the country? Great question. A number of U.S. states formally declared secession in 1860 to 1861, going into the Civil War. But that was 162 years ago. Yet, secession is still discussed by some.
This map here shows the percentage of residents in each state who stated in a survey recently that they favor their state seceding from the U.S. You can see that Alaska is at 36%, Texas 31%, Georgia 25%, Indiana 24%, California 29%.
Consider Google's search interest of the term secession, oscillating up and down over the years. Search interest alone doesn't tell us, however, why people are searching for this term, whether they oppose it or favor it.
So what's the short answer? Is it legal? Is it constitutional? The answer is actually a resounding no. It's not even a difficult question. First, the Constitution nowhere provides for secession. Second, in 1869, the third branch of the U.S. government held that no state may secede. This case was Texas versus White. In this decision, Chief Justice Chase declared that when Texas had been admitted to the Union, it was incorporated into the United States with finality. He described its admission to the U.S. as a relation that could not be dissolved or undone.
So, despite the fact that these acts of secession were ratified by the majority of Texas citizens at the time, the Supreme Court declared those formal actions to secede were in fact null and void and, quote, utterly without operation in law.
Texas versus White's ruling on secession remains direct, clear, and comprehensible despite having been written over 150 years ago. The third branch of the U.S. government is the only branch of government entitled to declare and state what the law is, especially in matters of constitutional law, like, for example, whether or not a state can actually secede. So the answer is clear that no individual state nor a part of a state can legally, constitutionally secede from the rest of the United States.